That is prior to giving approval.
By the competent authority.
Prior to giving approval.
By the authority.
So according to you, police officer should do that.
That's what the law says. Your Lordship, that is the requirement, my lords. So therefore, the application of.
Sir, two things.
Please.
If the crime is registered before the police, now if it or the lokaयुक्त or whatever it is, if it is touching upon or an amalgam of offence under the Prevention of Corruption Act and the IPC, prior approval will have to be sought.
Correct.
All right. The police officer or whoever files a prior approval before the competent authority to inquire or investigate. Permission comes, then he starts investigation.
Correct.
Starts investigation by what? By registration of a crime. All right. Now it is a private complaint. Straight away, a private complainant goes before the court. He seeks reference under 156(3), now under 175 of the BNSS. Now, if the matter is straight away referred, now say it is
not permissible.
No, that's what I'm telling you. If the matter is straight away referred for investigation to any authority, to jurisdiction police or to XYZ, no choice but to register the crime.
Correct.
So what happens to 17A?
So therefore, what?
By way of a private complaint, you get obviate the process under section 17A and straight away get a crime registered, where 17A, if it is before the police station or before the officer in charge of a particular police station, be it the lokaयुक्त, 17A would be required. All right.
Correct.
Now 17A, the approval is sought before the competent authority. Here the competent authority is the governor. Governor initiates certain process, not that day it is granted or what day it is granted. How it has been granted?
I'm not on that.
Yes. So according to you, Lalit Kumari had to be followed, preliminary inquiry had to be conducted. Now in the written submissions, the learned SG says that preliminary inquiry is conducted
by the
as contemplated under Lalit Kumari by the competent authority.
Which is not
that is your submission.
It's virtually impermissible. He does not act as a investigating officer under law. He only is a approving authority. What is sought by the investigating officer? That's the summon. And all and what the whole case and the record shows that 25th was the complaint, 26th the file movement. He was heard, show cause notice issued, and reply sought for, and a decision is taken, clarification sought from the complainant, and then a decision is taken, which according to them is a preliminary inquiry is what they have done. Can I read para 3, Malots? It is of the written submissions.
Yes, sir. Page?
Page 9, para 3. It is submitted that the stage of granting approval under 17A of the Prevention and Corruption Act, it is not a stage where claims and counterclaims have to be weighed or weight of the allegation is to be tested. It is submitted the only test that ought to have been adopted is whether there is an allegation which discloses the commission of a cognizable offence and apprehension exists that offence may have taken place, requiring an investigation to be conducted in accordance with law. Para 9, can I request?
Yes.
That is at page number 12. It is submitted the order to further understand the scope of inquiry at the stage of approval for investigation. The principles laid down in the case of Lalit Kumari versus so-and-so, the Honorable Supreme Court ought to be referred to. In the case, the Honorable Supreme clearly held that once the cognizable offence is disclosed in a complaint, the FIR must necessarily follow. The said principle was laid down in the light of statutory provision and so-and-so, and the understanding that the FIR is merely the starting point of a lawful means to uncover the truth of the matter. So the point here is, Malad, who has to do this preliminary inquiry? It's not in dispute according to them also, Malad, that preliminary inquiry need not be done. According to them also it has to be done. It says, I will do the preliminary inquiry. So therefore, my lords, there is no doubt that preliminary inquiry has to be done, even according to them. Then, my lords, page 14, para 10.
All right.
I'm sorry.
Yes. No. For whatever is to be done, preliminary or otherwise, 70.
Please,
all right. Yes.
My lords, what my submission is, preliminary, as your lordship in the initial start, preliminary inquiry cannot be read into 17 AM.
All right. We'll consider.
para 10, it is submitted that for the approval of investigation must be exercised by the, guided by law laid down by the Honorable Supreme Court. It submit in the case of information given to the police, discloses the commission of a cognizable offense, the approval for investigation is to be granted unless the allegation appears to be wholly biased, motivated, and false. In furtherance of the aforesaid, it is submitted that the intent of the Honorable Governor was to ensure the proper investigation is conducted in the present matter to merely uncover the truth in the matter and to take not to take any specific sides.
So according to you, according to them, preliminary inquiry is conducted by the competent authority.
Please. Ultimately, what they said, we have followed Lalit Kumari.
ಹೇಮಂತ್ ಹೇಳಿದ್ರಲ್ಲ ಇಲ್ಲಿದೆ ಬೇಡ.
Then one of the important aspects, my lords, with regard to your lordships, I have held in Dr. Ashok's case also, my lord. In this case, my lords, insofar as respondent number 3 is concerned, my lords, as I pointed out, complaint is given, not even 24 hours is what was ought to be waited for before approaching the governor on the 26th. Immediately, my lords, he is heard on the same day. That is one aspect of the matter, my lords. Whether you could have heard the.
After a few days.
No, not after, whether it could have been heard at all. At all. And what was thought to be argued, like the procedure need not have been followed. The question is, there's no such procedure. Rightly, my lord, there's no such procedure to hear the private citizen or a complaint. My lord, especially, my lord, when at the cost, allegations is made against an accused, whoever that may be, my lord, without his presence. And subsequently, my lord, issuing show cause notice, the whole procedure is not contemplated in the eye of law at all. When that being the case, my lord, the question, what your lordships will consider whether application of mind, principle of natural justice, reason order, I don't want to go into those aspects.
So you are at the root.
The root
It cuts at the root.
because the third, fourth, and the fifth complaint, my lords, here also I am not sought to give follow the requirement of section 154 or 173, my lords. If your lordship may kindly take the few dates in the written submission, my lords. Your lordship may kindly page 7, my lords.
Page 7.
Page 6, page 5, I'm sorry, my lords.
Oh, this table.
This table, which is forthcoming from the compilation of documents given from
All
the
right.
governor's compilation, my lords. On 18th July is the complaint given to the inspector of police, my lords, Lokayukta.
No, but it was argued that you had tendered an opinion saying that it is, they only have to seek the prior approval at 17A.
No, what, I'll come to my opinion later.
No, that's what I said. Because,
No, they have
no,
to.
now you are saying that police officer has to register, police officer has to seek permission.
No, they're slightly different what the opinion is given, what I'm submitting, my lord. Here, my lord, if they are complied with 154, my lords, as I submitted earlier, it is, he would have done a preliminary inquiry, then sought, as your lordship just pointed out, my lord, you would have, if it's a cognizable offense, you would have sought for a prior approval under 17A. The question is, my lord, whether 154 or 173 was sought to be complied. My lord, this 154 argument comes when private complaint is filed. But what my submission here is, my lords, the entertainment of the competent authority ought to have seen whether that procedure is followed prior to entertaining an application under 17A, my lord. The reason is this, my lord. If that was not followed, you should have seen that such a procedure is followed so that that material was with him. Here, my lord, 154(1) is not followed, or 173(1) or 173(3)(4) also is not sought to be.
151.
ನೀರಲ್ಲೇ ಬಿಡುದು.
154, 1 and 3.
1 and 3 has not been.
171.
ಮಾಡ್ಲಿಲ್ಲ, ಇದು ಮಾಡ್ಲಿಲ್ಲ, ಡ್ಯಾಮ್ ಮಾಡ್ಲಿಲ್ಲ. ಏನ್ ಮಾಡ್ಲಿಕ್ಕಾಗಲ್ಲ. ನೀರಲ್ಲಿ ಬಿಡಕ್ಕೆ.
Please, ma'am. So therefore, my lord, the, to entertain that application also, application 17A, my lord, this crucial aspect, whether the compliance of 154 my lord, was done, or 173, 1 and 4 was done, was very crucial. If that was not done, my lord, it ought to have been returned back, saying that comply with the said procedure, then you file an application. And in fact, insofar as Pradeep Kumar is concerned, my lord, that is respondent number 5, no such complaint is given at all. And insofar as respondent number 4 is concerned, my lord, application is filed subsequent to filing a complaint before the competent authority. And the competent authority has considered the application dated 5th July 2024, which pertains not seeking prior approval, but seeking CBI inquiry. So therefore, my lords, insofar as application of respondent number 4 for grant of sanction was not there, neither in the file of the competent authority, the Honorable Governor, my lords, or in the statement of objection. So therefore, my lords, the application sought for ought to not been entertained on this count also.
Yes.
Then finally, my lords, one of the point coming to now the aid and advice, my lords,
163.
163.
Hmm.
Insofar as courts, MP police establishment, and they've all said, my lord, the discretion is with the
Governor.
Governor. The question is, what is this discretion? How he has to exercise this discretion? For example, my lords,
Hmm.
on the basis of if the aid and advice or there is material, we'll take a situation, my lords, where recommendation is given grant, the aid and advice is to grant sanction,
Hmm.
and the same is rejected. It can work both ways. In this case, my lords, the advice is not to grant sanction, it has been granted. There may be cases, my lords, where recommendation is to the other way
Not to
around,
grant sanction, but sanction is, but sanction is to grant sanction, sanction is not granted.
not
All
granted.
right.
So therefore, my lord, this discretion is not his absolute power or absolute discretion which he can exercise. This is limited to what has been held by the Supreme Court in MP Police and Justice Punchi's judgment and Nawab Rabia and all these judgments. Ultimately, I just like to write 2 paragraphs of the judgments, my lords. My lordship may kindly take to page number, my lords,
48.
please. Page 41 for a moment, my lords.
The discretion begins there. Your
Uh,
submission is at page 48.
Okay. Note on points with regard to.
Yes.
So therefore, my lords, with regard to limited discretion, narrow scope of discretion, reason and caution, my lords, keeping that in aside, my lords, I'll just, where is that paragraph? Your lordship may kindly turn to page 55, my lords.
Hmm. Hmm.
At point number 4.
MP police.
Which has been reiterated in AG
Yes.
para 4. my lord. It is pertinent to note, as evident from the impugned order and the materials put forth by the governor, there has been assumption of bias contrary to the legal principles established in MP police establishment, Nawab Rabia, and so on and so on. So the exception carved out in this landmark judgment for when a governor may act against the advice of the Council of Ministers have not been addressed or satisfied in the present case. The impugned order and the material produced by the Honorable Governor fails to provide any substantive reasons from deviating from the aid and advice given by the Councils of Ministers, nor does it demonstrate how the Cabinet's recommendation against granting sanction was irrational or unsupported by material evidence or suffered from bias. Furthermore, the order lacks a reasoned explanation to establish its own rationality or to show that it is based on through consideration of relevant materials. This absence of reasoning, coupled with apparent haste in the decision making, raise serious question how the propriety and legality of the impugned order potentially infringes upon the constitutional scheme and governance principle of federalism.
Yes.
Your Worship, may turn to page 43, my lords, for a moment.
Hmm. Yes, sir.
The 43 last paragraph, my lords, 4.2.15
Yes.
explains, referring to Shamsher Singh and M.M. Punchi's commission's report, my lords. It's just been culled out over there.
Yes.
Which page 43 highlighted portion. my lord. Thus, the scope of discretionary power as provided in exception to clause 1 and in clause 2 of article 163 has been limited by clear language of two clauses. It is an accepted principle that in a parliamentary democracy with a responsible form of government, the power of the governor as a constitutional or formal head of the state should not be enlarged at the cost of real executive with the council of ministers. The scope of discretionary power has to be strictly construed, effectively dispelling the apprehension, if any, that the area of excessive discretion covers all or any of the function to be exercised by the governor under the constitution. In other words, Article 163 does not give the governor a general discretionary power to act against or without the advice of his council of ministers. This area of exercise of his discretion is limited. Even this limited area, his choice of action should not be arbitrary or fanciful. It must be choice dictated by person, actuated by good faith and tempered by caution. So this-
Prudence, caution, all right.
So, my lord, this is the, so therefore, my lord, your lordships will see, my lord, whether the impugned order comes within the four walls of this aspect. So therefore, my lords, the reasoning that the impugned order says it is my discretionary because there is bias apparent and evident is not a ground. As already pointed out, my lord, it should be by reasons with which the reasons should be in the order itself, not in the file, my lord. I would just like to take your lordship to the file for a moment, my lord.
Which file?
The governor's
Oh,
file.
all right.
Just I'll end with that, my lord. Just want to point out 2-3 aspects
Yes.
in that, my lord.
Madam, ಕೊಡಿ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
Volume
No, it's in volume.
1,
That's the order.
the order sheet.
All right.
Proceeding.
Yes, yes.
If
Page.
page, my lord, page 1, my lord.
Ah,
If your lordship sees, my lord, reference subject is sanction for prosecution, my lord, of so and so. Petition, so and so dated 26/7. Kindly produce petition by so and so, serial number 1.
hmm.
Then next page number 2, my lords.
Hmm.
Please pursue papers, pre-paras, the complaint addendum. Then next at page 3 on right on top, my lords.
Hmm.
I have heard so and so in person and gone through the petition and supporting documents submitted by him.
Hmm.
Prima facie, I am of the view there might be irregularities and misuse of power.
Hmm.
Hence, show cause notice to so and so within 7 days.
Hmm.
So this is what the preliminary inquiry sought to be done, my lord.
Hmm.
Then can I request, my lord, page 7?
Hmm.
Speaks about, my lord, the reply given by the petitioner, then the proceedings. Then last at para 20, my lords, put up along with the comparative statements of petition, chief minister's reply and cabinet decision.
Hmm.
Then at page 8, my lords, as directed at para 20, comparative statement of petitioners received so and so, reply are placed in the file for kind perusal. Perusal file discuss the issues, hence resubmit, kind notes, points dictated. Then this is page 9, para 25 is important, my lords.
Hmm.
Insofar as TJ Abraham, my lords, what is taken note of is the 26th July.
Hmm.
Insofar as Pradeep Kumar, my lords, is 14/8 and my lords, Nehemiah Krishna is 5/7, my lord. 5/7 pertains to referring the matter to CBI, not the additional memo which has thought to be filed on court. So therefore, my lords, what was sought to be argued on principle of law, my lords? In fact, your lordship's judgment in Ashok and Pradeep Kumar all says the reason should be in that order itself, my lord, because it is a 17A is a protection given to the public servant. The files or the notings in the
So file notings will not supplant
supplant.
what is not there in the order
What is
or
there.
supplement what
Sup-
is there in the order.
order.
Not
So
supplant.
therefore, to say, my lords, I did A, B, C, D, E, F, G, but my order may be wrong. But look at A, B, C, D, E, F, G. Ultimately, my lords, what is looked into is the order. If the order is bad, it's bad. So don't try to, as your lordship says, supplant the file to look into the order. If the order does not satisfy 17A, my lord, the order has to
Go.
go.
Yes.
So therefore, my lords, insofar as this legal, because these submissions are made on what the, therefore,
So, understand? Any other submission?
that's it.
Your synopsis, your written submission also is the same?
Same, my lords, on the same lines.
Why have stated position of the governor under Article 163?
No, not this governor, generally governor.
No, it, point 3 at page 656.
Please,
56 of your written submission.
my lords, this is a
Nothing.
federal structure, well, not insofar as this impugned order I'm talking about.
In general,
In general, man, I'm not dealt with the impugned order in specific at all.
Constant Assembly debates. Article 143 there.
Please. In fact, my lord, the discussion, I've enclosed those copies all over discussion, my lord. Ultimately, my lord, as your lordship, the discussion is there to what extent, it all depends upon facts of each case, my lords, which your lordship will consider.
Yes, sir.
I'm
Anybody
grateful to my
else?
lords.
Anybody else? Nimdidiya, sir.
I'll make my submissions after Dr. Singhvi.
Yes.
Dr. Singhvi is
Balance,
on.
I will be doing it on 12th, Balance. I will do it on 12th,
12th, sir. Yes, we'll finish it on 12th.
unless my review
The
petition
complainants,
succeed.
complainants have all completed?
Yes.
Yeah, they completed last.
You have submissions to make? No?
Reply to reply,
After the,
reply to reply.
after the reply by Dr. Singhvi, sir. All right.
Balance, after my reply,
Again, if you
Balance,
go on then,
normally-
this
no, after
rejoinder,
my reply, I
adella.
am a rejoinder, Balance. I will be doing a rejoinder. There can't be a
One minute,
reply
one minute.
after
Yes,
that.
sir.
Balance, after I reply, I had opened the matter, Balance. It has to be, if somebody argues after me, Balance, then I will need a reply to that also. No,
Then it will
except
go
my
on.
learned friend. No,
See,
except my learned friend on my
Whatever you
side.
want to reply, file by way of reply, and you want to any clarifications later, you submit on that day because you have not submitted at all. And sir, also, if you want 5 minutes, that's all.
No,
Oh, sir.
no, ಇಡೀ ಗ್ರಾಮ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Huh?
ಇಡೀ ಗ್ರಾಮ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಕೆಸರ ಗ್ರಾಮನ. I have to show it to the court. It is not.
No, my learned friend can.
No, he's sailing with you, sir.
No, I thought it's somebody else, fellas. I thought I didn't see his face.
Dr.
He can
Singhvi,
argue after me.
No, I said I'll make my arguments after you complete your arguments.
No problem. He's on the same
Yes,
side.
yes, that is
I
what
thought
I
it's somebody else arguing.
No,
Well,
no.
It is.
I'm only going to supplement what you make, what
No,
you
that's not
submit.
right. I misunderstood.
Without repeating
I
what
thought-
you said.
I thought it's somebody else. I'm sorry.
No,
ಸೊ ಕೆಸರೆ ಗ್ರಾಮ ಇದೆ ಅಂತ ಹೇಳ್ಬೇಕು.
ಕೆಸರೆ ಗ್ರಾಮ ಇದೆ. ಆಮೇಲೆ ಸರ್ವೆ ನಂಬರ್ 464 ಇದೆ. ಅವೆಲ್ಲ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ ತೋರಿಸ್ಬೇಕು.
ಇರೋದನ್ನ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ನುಂಗಿಲ್ಲ. ಈಗ ಹೇಳಿದ್ರಲ್ಲ, ಗ್ರಾಮನೇ ಇಲ್ಲ, ಜಮೀನೇ ಇಲ್ಲ. I'll show. Where is the village? Where is the? I'll show.
All right.
Okay.
So this will go on and on. I am
No,
not.
I am only going to reply. No, sorry, I am going
Right,
to
1 minute.
reply.
Sir. 1 minute, 1 minute. The right of reply is always there. You have submitted, right of rejoinder submissions is always there. If any clarification to that, yes, you can't go on and on like this and it's not it becomes a circle, sir.
Whole day it was argued saying that Kesara Grama is not there.
No,
I will
1 minute,
show
sir.
where is Kesara
1 minute. For whatever you have submitted, they have a right to reply, they will reply. Then after that, it's not that you have a right to reply. It's not like sir rejoinder, filing sir rejoinder, sir submissions here.
Reply to reply is unknown, sir. Unknown.
But they will, sir, you, 1 minute.
I don't know why my
You
learned
have
friend
made some
is-
submissions. They have a right to rebut, 1 minute, rebut those submissions. If it is by way of new things, what can be done?
No, I
In
don't know. why-
justification, they will say whatever is there. Allah, I can grant time, that's not a thing, but it will go on. How long do you argue the same thing?
So 12th, Malas, 12th.
New proposition, where is the new proposition, sir? You have submitted the whole day on 31st from 10:30 to 4:45. We'll see. You also want to clarify?
With respect to the chief minister's role that your lordship.
All right, let Dr. Singhvi sir finish it. We'll see, yes. 15 minutes. No. We'll see. First, let the respondents finish. Avatte ಮಾಡ್ತೀರಾ sir ನೀವು?
Petitioners, yeah. ಅಲ್ಲ,
Petitioners.
ಅವರು Dr. Singhvi ಮುಗಿಸಿದ
The moment
I don't
Dr.
want to
Singhvi
repeat.
completes your-
Yeah, I'll immediately start.
Malas, let me just make one thing clear. If anybody has any new point, they should give it to your lordships today or tomorrow. Because if when I'm rounding it
Today,
up,
no new points, sir.
after my finishing, if somebody argues
No,
other than Mr.
just a
Ravi
moment,
Kumar,
then you submit
let
whatever
me
you want to
discuss.
submit.
That's your lordship.
If you want to state about the role, please state. Then Dr. Singhvi sir will reply to that also.
That's all, Malas.
I will hear you. How long will you take?
5 to 10.
That's all. Then you, if you're ready, you state. Yes.
Lordship,
Obliged.
Your lordship had put forth rules. What is the role of the chief minister ultimately in this entire matter?
Yes.
Key words are check period. Check period, your lordship. What happens is in all prevention of corruption matters, the date in which the position of power was held by the person, that is critical. Check period is what is taken into account for any irregular accounts that have entered into the person's account or the wife or any other family member. If the check period is gone into, then all of this falls in place. Your lordship, ultimately, we are only looking at when are the periods in which the petitioner held a certain post, and that is the time during which all of this took place. Your lordship, it is only between the year 1996 to 1999. 1996 to 1999,
Deputy Chief
he was the
Minister.
deputy CM. That period, your lordship, is the denotification period. I'm not going to expand further. The 1996 to 1999 is the entire denotification period which took place, and subsequently is the year 1999 to May 1994. That is the period when
2004.
2004, wherein the petitioner was not in power since he had lost his elections. Therefore, your lordship, that period is the lull period. Nothing takes place then. After that is during the period of 2004 to 2007. That denotification portion is over. So therefore, 2004 to 2007, the conversion phase starts. So from 2004 to 2007, documents are already there and they have gone into in length in that. So that is the conversion period. Subsequently, 2008 to 2013, your lordship, this is when this transfer takes place from A4 to A3 to then A2. That happens between up to 2010. Your lordship, between the year 2013 to 18, when he is the chief minister, at that point of time, A2 takes over. The vice gives all the representation stating, give us compensatory land. So the phases of denotification, phases of conversion, and then phases of submissions of representation, and then seeking compensatory lands. Your lordship, the key period that the petitioner seems to state is that all of this took place when they were not in power. Your lordship, what happens is the year 2018 to 22 is critical. 2018 to 2022, the petitioner was very well an MLA. Now, it is not about which political party is in power. It's ultimately, did the individual hold a position of power or not? He held a position of power at that point of time. And at that point of time, what happens is that the 14 sites that are allotted are done at a government guest house, done specifically for that. Your lordship, what happens is A2 doesn't go to the sub-registrar's office when Muda gives this.
That's permissible in law.
That is permissible under the
For the
Registration
purpose of
Act.
registration of sale deed.
Registration of sale deed, that's permissible under the Act only for the person who's exempted from his presence there.
Disabled.
Disabled is one. There is also a list of people who need not be present at the sub-registrar's office. And that
So
is
you're attributing the connection to power.
absolutely every single act that has taken place has been done on behalf of the petitioner, and that has been established all through. And then subsequently, when actually the year of 2023, when all of this is unfolding, at that point of time, the petitioner says, all right, take my 14 sites, give me 60 crores. And so starting from the period on which we start with denotification, where A1 makes A4 to do all of this. That is, the petitioner asks A4 to do it. Up to the time they say, all right, give me back my money. From then onwards, the role is established. Your lordship, we have only given a set of judgments which the others haven't, and only those we will mention, your lordship. These are only with respect to check period. Check period, your lordship.
In a Prevention of Corruption Act case.
In Prevention of Corruption Act cases, your lordship,
Yes.
I'll
from
very quickly-
Period A to period B.
period A to period B.
Date of joining service till the date of search.
Absolutely. And in most of the cases, your lordship, it is more of disproportionate income, and therefore they calculate the income during the time when he was in power and when he was not in power. In this, there is a
But
slight
how is the
shift.
concept of check period relevant to this, or you're trying to paraphrase that to this?
If we are drawing a parallel, in this, there is no money that you could attribute to have entered into at that point of time, but it is directly attributable to the acts that have taken place during that time. Your lordship, and also with respect to what is the role, all of these judgments, your lordship, I will not take your lordship into detail, but all of these judgments only state that even if, let us assume that the wife, that is A2, would be probably not working, or would have a source of income, maybe an agricultural source of income, and would file income tax returns. Nevertheless, the courts have held that if the person who's in position of power has purchased certain properties in the name of the wife or in the name of any other family member, it would still ultimately be attributable to them and their role in all of this. Directly, your lordship, all of these judgments, your lordship, I have,
Paragraphs hakidira?
your lordship,
You've
we've put
indicated
in.
the paragraphs of these judgments?
Paragraphs
Yes,
have
yes.
also been mentioned, your
Yeah,
lordship.
yes.
In Ponuswami's case, Parmasivan's case, Balashankar Lingam's case, then
Yes.
Ponnumudi and Soundararasu, and also Wahidida Jayaraman, your lordship.
All right.
All of this directly on the point of when a particular person is in power. And that should probably connect the dots, your lordship. That's
So that's the link that you're trying to draw.
absolutely. And to say that I was not in power when all of these 14 sites was allotted, he was definitely in power.
No, not in power is not the submission, but not taken any decision directly or any recommendation made by him. That is the submission.
Your
He was
lordship-
in power, that they accept, that's a matter of fact.
Please,
Yeah.
your lordship, anyway, the judgments are clear. We don't need a direct recommendation or any letter from them. If we are able to show the link at that point of time. For example, how I've been able to establish that the time when he was not elected, there's a lull period. But all the times that he's elected, activities have taken place. So that is sufficient. And the question always should be, what is the role of A2, A3, and A4, as opposed to asking what is the role of A1? Because A1 is established very clearly. A2 and A3 and A4 could be at best aiding or abetting. And that is something, it's just a matter of trial. But with respect to A1, it's very clear. That's about it.
All right, yes. Yes, now, Professor Sir, you have heard the council also. Elladakku seri reply on 12th. Singhvi sir?
Yes,
On
Palas.
on 12th, sir.
Yes, 12th, Palas.
12th, we'll take it at 10:30 or at 2:30?
Well, it's not at 10:30, but maybe around 12 or 11:30 or
All
something.
right, we'll take it at
I will come
12-ish.
to the court, yes.
Yes, sir. 12 o'clock.
Yes, Palas. Obliged.
Heard the learned council Ellardu Hakpade and council Srimati Lakshmi Iyengar appear for which respondent, for the fourth respondent. The respondents have all completed their submissions. The learned advocate general has also completed his submissions for the reply submission of the senior counsel, Dr. Abhishek Singhvi, and the senior counsel, Professor Ravi Verma Kumar, list this matter on 12th. 12th, we should be concluding this, sir.
Yes, well, yes. Obliged.
ಏನಾರು ಇದ್ರೆ 5 ನಿಮಿಷ ಅಲ್ಲೇ, ನೋ ಡ್ರ್ಯಾಗಿಂಗ್ ದ ಪ್ರೊಸೀಡಿಂಗ್. ಅದೇನ್ 15 ಇಂದ 10ಗೆ. Let them finish it first on that day. Huh? What do you want to say? The legal submission, sir. ಮತ್ತೆ ಅವತ್ ನೋಡ್ 12th. Yes, ma'am. List on 12th at 12 p.m. 12.
The judgment supported.
Let us hear. Yes.
No, I don't have any more to say.
Yes, sir.
I have done whatever I had to.
Yes, sir. Yes.
The judgments which I have given along with the note, Malot, the full judgment copy has been enclosed, Malot.
ಅದಕ್ಕೆ ಇದೆಯಾ?
Allah, separate
Separate
compilation,
ಕೊಟ್ಟಿದ್ದೀರಿ.
separate compilation has been,
There are about 12
Yeah.
compilations of judgments now.
we want
ಬರೀ 2500 page judgments ಕೊಟ್ಟಿದ್ದೀರಾ.
for a 6-page prior approval.
Yes, sir. We'll see. Yes, madam. Yes.
Grateful.
Now ಅದೇ ಹೇಳೋದು for a 6-page prior approval ಇಷ್ಟಬೇಕಂತ.
Allah.
Now,
Mr.
we-
Raghavan has-
ಹೇಳಿದ್ದು.
Mr.
Please.
Raghavan has come.
role is sort of explained by the senior counsel Lakshmi Iyengar. Now we will reply to that.
I'll do. I'll do. No, interim order needs to be.
That will be extended.
It took so long
For what?
to explain the role.
That is my investigation. That is my investigation.
Your Lordship, the League of Extraordinary Gentlemen went on a marathon. Ultimately, a lady had to take your Lordship through a 100-meter dash.
Let's see. Well, hear it on 12th. Yes. List the matter on 12th at 12 p.m. We'll start at 12 sharp. Sir will be appearing physically or Singhvi sir?
No, Manoj, I will be, I'm coming there physically. Manoj. That's why. Very
Ah,
grateful.
yes. That's fine. Yes.
Yes.
ಬರಕ್ಕೆ ಹೇಳಿ. Two 30 minutes. Settlement. ಒಂದೇ ನಿಮಿಷ. Child is there, is it? End of play settlement. Take it. Give it. No problem. Give it. Where the child is there, please give it. Yes. Get that matter, madam.
First matter, there are 5 petitions. All of them are present.
498A. No, let the mother stay out with the child in this rush, not. Oh, fine, yes, fine. All right, yes. No, they are the accused, but where is the complainant is present?
Morning itself, I make a call to the complainant, she is not.
Not willing to settle.
Not well,
Huh?
she is not well, Manoj.
Not well. We can close it. Settle ಆಗಿದೆಯಾ?
Settle ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, but
On 16, the order has been passed to the family.
ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ? ಮತ್ತಿನ್ನೇನು ಕೊಡಿ. ಎಸ್. ಮತ್ತಿಲ್ಲೂ ಏನು ಡಾಟ್ಸ್ ಮಾಡೋದು? ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆದ್ಮೇಲೆ ಕೊಡಿ.
ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಚೈಲ್ಡ್ ಪಾಸ್ಪೋರ್ಟ್ ಒಂದು ಕೊಡ್ಬೇಕು, ವಾಪಸ್ ಕೊಡ್ಬೇಕು.
Child ದ?
ಚೈಲ್ಡ್
ಕಂಡೀಷನ್ ಇದೆಯಾ ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ?
ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ.
Passport is expired. It was done when he was 6
So
months.
both of you cooperate and get it extended, and visitation and holding of the child or the passport. Child is in whose custody? Child is in whose custody? Mother's custody. So you'll apply for renewal or reissuance. Expire ಆಗಿರೋ passport ಅವ್ರು ಇಟ್ಕೊಂಡ್ರೇನ್ ಬಿಟ್ರೇನ್? Yes. All right. ಕೊಡಿ. We'll close it. Don't ಎಲ್ಲ ಆದ್ಮೇಲೂ ಡಾಟ್ಸ್ ಮಾಡೋದು ಬೇಡ. Yes. Petition ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದೀರಾ? All right, you take it as settled. Conditions ನಿಮ್ ಪೇಪರ್ ಕೊಡಿ, ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ಕೊಡಿ. Give that. Vijay, parties were before the family court as well. ಇಲ್ಲಿ settlement ಇದೆ, ಅದರಲ್ಲಿ mark ಮಾಡಿಕೊಟ್ಟಿದ್ದೀನಿ. One of the condition is closure of the proceeding. Point number 11, ಬೆಳಗ್ಗೆ ಹೇಳಿದ್ದೀನಿ ಅದು. The learned counsel appearing for the complainant would submit that the settlement is indeed arrived at, but has some grievance about the passport of the child being held with the husband. The learned counsel representing the husband would submit that the passport has expired 3 years ago. The child is now 8 and the passport had expired when the child was 5. Therefore, the respondent mother in whose custody the child is always, it is always open to her to apply for reissuance of a passport in accordance with law. ಅದೊಂದು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟು ಕ್ಲೋಸ್ಡ್ ಅಷ್ಟೇ ತಾನೇ ನಿಮ್ಗೆ ಎಕ್ಸ್ಪೈರ್ ಆಗಿರೋ ಪಾಸ್ಪೋರ್ಟ್ ಮೇಲೆ ಸೊ ಅಂಡರ್ಟೇಕ್ಸ್ ಬೋತ್ ದ ಮ್ಯಾಟರ್ಸ್. ಎಸ್ ನೆಕ್ಸ್ಟ್ 230 ಮೂಡ್ ಮ್ಯಾಟರ್ ತಗೊಳ್ಳಿ. ಪಣೀಂದ್ರ ಸರ್. ಅದ್ ನೀವು ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ್ದು ಅಂತ ಗೊತ್ತು, ಅದಕ್ಕೆ ಕೇಳಕ್ಕಾರ್ತೀನಿ.
Girl and boy knew each other in college.
Girl and boy knew each other?
But this is the wife's complaint. After marriage, after I filed a divorce petition, first time she files one complaint, my lords, alleging
Poxo.
Poxo on the wife.
Poxo.
Not on the wife, not on the child. After the divorce petition.
No, 1 minute. What was the age when both of you knew each other?
But she says in 2019-20 we came to know each other.
Huh.
Now
What was the age, her age then?
17 years and 8 months.
All right. After that you get married when?
That's on 2021.
No, but what was the age of, what was her age when she got married?
She was born at 21 years.
No, the girl was above 18. Yes, all right.
In fact, on 25/10/2021, I had given a complaint. Saying she's coming, my father had given, that's the second accused.
Second.
Father, she has involved father, mother, aunt, everyone in POXO 498A SC.
Poxo.
Now, my lords, 21 I give a complaint, she gives an undertaking, she's not trouble. Then, my lords, the boy and girl elope and get married in Hassan, registered marriage. She admits marriage. Then, my lords, there is trouble between us. Then she gives one complaint to the police saying that he is troubling me, counsel me. We go undergo counseling, it fails. Then, my lord, 498A, she lost this. By that time, I had filed a divorce petition. This honorable court grants anticipatory bail on 27/5/2024 on 498A. 6/6/2024, she files a complaint saying I had, my lords, raped her in 2000. That is invoked. 498A first complaint, there is nothing.
And Jagdish sir,
Yes.
25 days ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಿ. ರೆಕಾರ್ಡ್
ಈಗ ನೋಡ್ತಾ ಇದ್ದೀನಿ.
ನಾನು ಈಗ ನೋಡ್ತಾ ಇದ್ದೀನಿ. Date 26/6/24 crime, 24/7/24 charge sheet.
Yes.
Very fast, sir.
And in all the records, father's name is shown as Rajappa.
Who is that?
How she says, my father is Nayak, to claim my lord's SC/ST, she says, her school records, everything shows Rajappa. She says, Rajappa.
Who is Rajappa?
She says, I am the adopted daughter of Rajappa, my father is Nayak. Please see her school records.
CST Atrocity Act 6, charge sheet has to be filed within 60 days. It has to be
ಇದು
filed.
3-1 R&S ಬೇರೆ ಇದೆಯಾ ಅದಕ್ಕೆ?
What?
Any offense left?
R&S.
Nothing more, I don't know, my lords, everything. The boy had to spend 1 month in custody, though he had anticipated. Parents spent about 15-20 days in custody.
Object achieved. Yes. Heard the learned senior counsel, K.N. Panindra, appearing for the petitioner. The petitioners, petitioners accused 1, 2, 4 are knocking at the doors of this court, calling in question filing registration of special CC 1493 of 2024. The facts would read as follows. It transpires that the first petitioner and the second respondent complainant knew each other while pursuing their engineering. They fall in love, get married on 23/10/2021. You have a child also? 13/1?
13th of January 2023, the marriage.
On 13 January 2023. Soon thereafter, it transpires that the relationship between the first petitioner and the second respondent complainant flounders. And on the floundering of relationship, certain proceedings are instituted. The husband institutes proceedings seeking annulment of marriage before the family court. Thereafter, the wife registers a complaint. For what offenses is surprising to notice. The wife registers a crime for 498A. There should be no problem with that. The wife further registers proceedings for offense punishable under section, further registers complaint for offense punishable under section 376, 354C, 506 and 34 of the IPs. Charge sheet is filed by the police invoking POCSO. The reason for invoking the provisions of POCSO is before marriage, the relationship, the petitioner is alleged to have had physical relationship with the complainant, at which point in time she was less than 18 years. The marriage having taken place later and the floundering of the relationship between the two cannot give rise to an offense under POCSO which had taken place earlier, albeit prima facie. All the other offenses would touch upon the disputes between the two and the crime being registered as a counterblast. This is again a view that is prima facie. Therefore, till the appearance of the second respondent complainant, there shall be an interim order of stay of further proceedings in special CC 1493 of 2024, 1 additional SPP, 2 emergent notice returnable by 26th September.
Number 2, Shyamki Asthratv.
Settlement. An offense?
360.
Offense.
506. It's between a husband and wife. The complaint is the husband as against the wife.
Extracting money.
What they claim. However, the matter is settled with the party.
Who is the complainant? Why,
He
if the wife asks you money, it is extortion, is it?
No, my lord.
ಆಯ್ತು ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಬಿಡಿ ನಮ್ಗೆ ಯಾಕೆ ಕೊಡಿ. Yes.
The respondent number 2 is appear via VC.
Huh?
Respondent number 2.
All right, yes, give it. Settlement close ಮಾಡಿ ಅನ್ವಿಜ್.
Application under 359 sub.
So and so totally. Application is filed on 359 BNSS, not 320. So and so settled. Copy ಅವ್ರಿಗೂ ಕೊಡಿ. 363 ಅಲ್ಲ.
Copy ಕೊಟ್ಟೇ ಇಲ್ಲ.
ಕಾಪಿ ಕೊಡಿ. ಗವರ್ಮೆಂಟ್ ಕಾಪಿ ಕೊಡಬಾರ್ದು ಅಂತಿದ್ಯಾ? Not this, sir, your settlement copy, sir. Give it.
Petition copy.
Petition copy no ilva?
230 mood matter ಮೇಲೆ copy sir not.
Other, yes. Forgery, sir. 465, 420.
Connected 498 case was settled before the court on number 22 ಮೇಲೆ today itself.
Today?
Yeah, criminal petition.
Oh, all right, sir.
That is 2019 made.
No problem. Close it, yes. I would.
Order sheet signatures.
The respondent number 2 appear VC.
Thank you, my lord.
Yes, thank you. Yes. Hello, pages karbiಡಿ.
Page 6, seal number 36.
NDPS.
NDPS.
ಹಾ ಗೊತ್ತು.
It was for dictation.
Today not possible.
Please.
18th.
18th.
Yes.
Obliged.
List on 18th. Next.
67, 37 to 41.
Wherever interim order is there, they'll continue. Will they rather 18th?
40 Millard.
Where there is no interim order, they'll come on 18th.
40 Millard, last 2 dates it is.
Huh?
40 serial number 40.
ಏನಾಗಿದೆ sir?
Date also it is urgent. Last date also it is urgent, my lord.
Last date?
Also it is urgent for today.
This date also it is adjourned. Can't tell.
Right.
List on 18th.
List number 1 is arrested.
All matters where interim orders are not there, they'll come on 18th.
My lord, my submission will be number 42.
Wherever interim orders are there, they'll get continued
My lord,
for period for 2 weeks.
My-
Next date of hearing.
my submission, my lord, petition number 1 is subsequently arrested, my lord, and
Subsequently arrested, why?
after filing of this petition.
Why?
For offenses under 376, my lord.
376.
376.
Parallel.
Now the parents who are in Chhattisgarh, my lord.
Huh?
Now the parents who are in Chhattisgarh,
ಅದು ಯಾವ್ದು ಮುರಳಿ ನೀವೇನಾ?
please.
Interim order ಇಲ್ಲ ಅಲ್ವಾ?
Still has entry matter. Last date also it is.
ಅದು ಲಿಸ್ಟ್ ಆನ್ ಮಂಡೇ ಎಂಡ್ ಡೇಟ್ ಮೇಡಮ್ 16, 17 ಅದ್ರ ಬದಲು 18th ಬರುತ್ತೆ. 17th in the fresh matters list. All right. Serial number 40 ಮಾತ್ರ. Because he is arrested, yes.
Please.
Interim order ಇದೆಯಾ? $55. Tomorrow ಆಗಲ್ಲ madam. Tomorrow not possible. Wherever interim order is there, they'll continue for 2
Number
weeks.
52, my lord.
ಅದೊಂದು ಮಾತ್ರ day after tomorrow.
52, my lords, it's concerning default bail. 52, my lords, it's concerning default bail, my lords.
Default bail ಯಾವ್ದು?
52.
52.
Please, my lords.
52 also list day after tomorrow in the fresh matters. ನಿಮ್ದು default bail ಆ? Where is it? Pokso na? Pokso is 20th. ಯಾವತ್ತು?
Serial number 62, my lord.
Huh?
Serial number 1 was arrested subsequent to filing the petition.
ಜಗದೀಶ್ ಏನ್ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ರೆಸ್ಟ್ರೆಂಟ್ ಆಕ್ಟ್ ಇದೆಯಾ?
Serial number
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕಿ ಮೇಡಮ್. ಅರೆಸ್ಟ್ ಆಗಿರೋದು ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕಿ.
Serial number 40.
Supposed to be listed fresh matters, my lord. Serial number 50, my lord, the matter was listed before you last.
ಸರ್ ಇಂಟರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂದ್ರೆ
Fresh list ಆಗ್ಬೇಕಾಯ್ತು, fresh.
ಆಗುತ್ತೆ. ಇವತ್ ನಾಳೆ ಅಲ್ಲ, 17ಕ್ಕೆ ಆಗುತ್ತೆ ಸರ್.
Serial number 39.
Serial number 12 for settlement.
ನಾನೇ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮತ್ತೆ ಹಾಕಲ್ಲ.
Subjection over.
ನೋ, ಅದು ಬರೀ ಆತರ ಇದ್ರೆ ಬರುತ್ತೆ ಅಷ್ಟೇ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಓವರ್ ರೂಲ್ ಅಲ್ದೇನೆ. 1 minute sir. Don't argue with the court officer. Now, no. If I have issued notice without granting an interim order, it will come only in admission after the appearance. Yes, sir.
Serial number 39. ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಬಿಡಿ.
Madam, actually second list ಅಲ್ಲಿ ಇತ್ತು madam ಅದು.
ಬರ್ಕೊಂಡಿದ್ದೀನಿ.
Madam, serial number 12 ಯಾವಾಗ?
Rise entrepreneur. Take that first step towards freedom. There's an industry that needs your disrupting ideas. It takes courage to do what you love. We'll help you begin your journey as a business, like you, dedicated to you. Submit just 4 documents and register your business with Zolvit in just 7 days.
Thanks so much for tuning into this broadcast. The case for a chat with our guest today. I really want to ask him if rate cuts, potential rate cuts, if they come, or the festive cheer, can it spur the sluggish growth scenario? Because it is starting to look at the margin a bit worrying. Can DII flows sustain the Nifty rally? They have done that thus far. The heavy lifting has been done by domestic flows. Can it actually take it further to what some people would say egregious valuations? Also, while PSUs had a fantastic 2023, the second half of 2024 has been anything but great. Do PSUs have investable pockets, or is it a wait and watch? To talk about all of this and more, Vetri Subramaniam, Chief Investment Officer, UTI Asset Management Company, with us on the show. Vetri, so good having you. Thanks so much for taking the time out.
Always nice to talk with you, Neeraj.
Thank you so much. Vetri, I want to start with a million, billion, trillion-dollar question. A lot of bulls have been mentioning that we are closer to the Fed easing cycle, and that by itself at large should be constructive for risk assets. The overhang from the US elections will also go away in November, and assuming it's a market favoring verdict, there are multiple cues which might actually spur risk assets further. Do you agree, or is it not as simple as this?
Well, I think, the broad perspective that, yes, we may have seen a peak in the rate cycle in the US is certainly good for the economy. But as far as risk assets are concerned, I would actually submit that it looks like, the risk assets have already climbed that wall of worry. Because remember, it was way back in 2021 when we started to deal, with the prospect of significantly higher rates. And that did trouble the markets for almost about a year, or maybe slightly less than a year. But markets stopped responding to rate hikes even towards the end of the rate hike cycle. And if anything, they've actually powered to not just new price highs, but also significantly higher valuation levels in the expectation of rates starting to go down at some point of time. So I would actually say the rate cut cycle is pretty much in the price. I'm not sure there is any scope at this point of time to suggest that because rates go down, you will further see assets getting marked up. Why? Because it's already happened. The market is already looking forward. It's already factored this.
So, okay. So in which case, Vetri, assuming that the economies, both West, China, and to an extent we are starting to see good growth. Moody's has upgraded India growth, but telltale signs from auto companies, etc., seem to suggest that there is a bit of not a growth scare really, but a wrinkle on the banana peel, if you will, kind of a scenario emerging. What do equities by and large do when growth is not quite there, but there is an easing cycle? So we've rallied. Do we correct, or do we maintain those levels and valuations?
There are many elements to the question you're asking, Neeraj. And first of all, I would say it is not even clear that we are in a synchronized growth cycle across the world.
True.
China has been having its own issues, and their growth cycle is currently completely disconnected with whatever is happening in other parts of the world. I would also submit that if you look at India, maybe because of the policy mix that we used, the fiscal conservative, not very aggressive on the monetary side, our growth cycle came out and it has sort of held up at a reasonable level, very different from what's happened in the West, where excessive monetary and fiscal stimulus is causing the